Hey folks, welcome. Dave Brannen here, ready for another day of Ask a Lawyer Live. Today we're going to be touching on a employment law situation and talking about what happens when you're denied medical accommodations at work. As always, please put your questions in the chat and I will get to them. I already see some questions that are in there already, so that's perfect. I'll get to those as soon as we get through this brief presentation on medical accommodations at work. So hopefully you can stick around. I'll be no rush today, so I'll be sticking around answering questions as long as needed. And let's dive in. So let's go with the easy question. What is a medical accommodation? So medical accommodation means that they are changes to your job or workplace that help you manage a medical condition. This could include modifying your duties, flexible hours, ergonomic changes to equipment, sometimes even working remotely. The goal is allow you to keep working safely and effectively despite the kind of medical challenges that you have. Now, you do have a right in Canada to accommodation. This is protected under provincial and federal human rights laws. Employers have a legal duty to accommodate employees short of undue hardship. So that will be relative to each employer, what would constitute undue hardship for them. It is a high threshold, though, and as an employee, you have a duty to cooperate with the employer so that they can determine if they are able to accommodate you. For your purposes, that means you have to give them some information about your medical limitations and documentation to support your requests. All right, so common reasons you might be denied an accommodation. There's a few of them here. So the first one is the one that legally is allowed, that it would cause the employer undue hardship financially or some safety reason why they can't accommodate your illness. So this is something that can be legitimate. So it will depend on the size of your employer, the resources they have available, and what you would need in order to accommodate your needs. Now, another reason you'll see accommodations denied is if there is lack of clear, specific information about what accommodations are needed. Some employers will will use this in good faith or in bad faith when they will legitimately need more information, or some of them will just use it as a way to try to make it more difficult for you by just saying more information is needed to just make it frustrating so that some people just end up leaving. Now, there can be misunderstandings about your conditions or needs. Again, that can be in good faith or bad faith. If it's good faith misunderstandings, it usually just means you have to get more information from your doctors about what is required. And sometimes, look, there's just outright discrimination against people with a disability. I deal with a lot of these cases. I was working on 2 today, as a matter of fact, just before I came on the show here. So it's just common that employers will want to get rid of employees who have medical issues. We handle a lot of cases involving people who are fired shortly after coming back from a medical leave, or when they give notice that when they're going on a medical leave. That is something that does happen. And if it does, then you probably have a pretty good employment case against the employer. All right, let's take a look here at the next slide. So what do you do if you're denied accommodation? Well, it's important to keep a lot of notes. I recommend taking notes and not doing secret recordings of things. So take a lot of notes about what's going on. Ask for any denials of your request for accommodations to be done in writing. So even if you have a conversation with someone about it, you could email them afterwards to say, just confirming our conversation, here's what was said, something like that. You do need to get a paper trail, like something documented down. You don't want to rely on just your memory of what was said. It's better at the time that these things are happening to create documents that are made at the time so they will be more credible later on. If you're several months later and you're trying to recall what was said in conversations, that's not as effective as if you have documentation that was done at the time describing the events. You want to review your employer's response with your doctor. So the doctors sometimes can just clarify what's needed. There is a delicate balance because the employer's not required, they're not allowed to have all the information about your medical condition. The way the law works is they're entitled to the minimum amount of medical information needed for them to, whoops, sorry, for them to be able to determine if they can accommodate you. So that is what you want to keep in mind. Ultimately, if you do get a denial, you want to look at it and see, was this a good faith denial of the accommodation? If so, you can get more information together, speak with a lawyer, and figure out, can we provide them more information to hopefully get this approved. All right. And legal options, basically, there is a few here. So if it depends on you're unionized or non-unionized. If you're unionized, then you can go through the grievance process. If you're non-unionized, you can file a human rights complaint through your provincial human rights commission, or if you're in a federally regulated industry, you could go through the Canadian Human Rights Commission. You can also speak with a lawyer to determine what your rights are and if it makes sense for you to pursue a discrimination case. These are my favorite employment cases to do, just because we do have a lot of experience in dealing with disability and medical illness and things at the firm. So my favorite cases involve, for employment cases, they involve situations where people are being let go and it's linked to their medical condition or disability. Okay. And okay, a few things here to finish off. So I think I've already covered this, but you want to cooperate. Again, take notes. Don't do secret recordings. When to get legal you want to get help is if they're just ignoring, or if they've got this. Sometimes some employers will just do a never ending, like you'll come back with more information and they'll say it's not enough information, but they won't be specific. So you have to determine if they're acting in good faith or not. The best thing to do is just get legal advice to determine if your employer is acting in good faith. Because if they're not, then you could be in a situation where you could already launch a case against them if they're not acting in good faith. All right. That's it for that. Let's dive into some questions. We have a question here from XRP. Let's see what the question is. It's a two-part one here. Gainful occupation question. My index salary was $110,000 a year, but my actual salary was never under $200,000 a year. Contract says my gainful occupation is 60% of my index salary, comes out to 66 per year. I find that unfair. Is this negotiable if we ever go to court? Well, not really. Like, the rules, unfortunately, will be what your policy says. So I'm not sure how the policy, where they're coming up with the index salary, but if you agree that your index salary is what it is, then, and usually that's your base salary, you probably had other compensation and bonuses and things like that. So it is common for these policies to focus on the base salary and to exclude bonuses and commissions and these other things. It is legal to do that as long as that is what's written in the policy. It's a contract, right? So you'd have to review the policy and make sure that legally that is what's in there and that's what they're allowed to do. But if it is, then it's not really something that's negotiable because it's in the contract. The only times things are negotiable in the contract is if the language is a gray area, like it's ambiguous, and there's a dispute where you could say, well, we're interpreting this way and they're interpreting that way. That often leads to a claim denial, and that becomes part of the negotiation. And sometimes settlements and things are done based on some compromise between both sides, knowing that if it went to a judge would have to pick one way or the other, and it can go both ways. So, yeah, I would say, unfortunately, it's likely that if that's what your contract says, then it would likely be upheld. Now, if you're still around, XRP, you can put in some follow-up questions there if you have any. While I'm waiting for questions, I'm going to dive back into the forum, the Resolute Legal Forum. We're going to go look at and see if we've got any questions we can do there. I'm just going to share my screen with you folks. All right. Oop, I'm a little small there. There we go. So while I'm waiting for other people to put their questions in, let's take a look at what we have here on the forum. This question, let's see what this one is. Oh, yeah. Oh, wait a second. Okay, this is new. Well, it's from July 2024. There must have been a follow-up question or something. Yeah, okay. This is just people finding out what happened. This person, let's just see what this person was saying. So this person was saying, has anyone gotten a letter during the Social Security Tribunal General Division process stating that they, Service Canada, notify the tribunal member that the minister is developing additional information on the appeal? The navigator said it was something to do with reviewing the file they've already rejected twice, and I haven't submitted any new information. I had a call coming through there that I can't take. Um, the navigator said it was something to do with reviewing the file that they've already rejected twice, and I haven't submitted any new information. Yeah, it could be. It could be that they are. It really could mean anything. It really could mean anything. It might be that they are. Sometimes they will reassess your. They'll reassess your minimum qualifying period and that type of thing. Sometimes it is that they want to request new information from you, but that person would have known that. They didn't respond, so we don't really know what happened in that situation. But all right. This one here says, has anyone received a direct letter from Service Canada during a tribunal appeal? Yeah. Okay. Yeah. I was talking with this person. Okay. It looks like there were some posts deleted here. Not sure what the. Okay. They're just asking to help delete it. My appeal request with new evidence is complete, and my appeal at the Tribunal General Division is moving forward as I've been assigned a navigator. This information was received from Service Canada after reconsideration. Decision maintained its decision at the General Division level. Oh man, I don't know what's going on with this poor person. Yeah, it's just like there's no there's just they're mixing things up a little bit. Just honestly, it is a little bit confusing, but there's no. Oh, okay, okay. Okay, I understand what they're saying then. They're just saying they got a letter from Service Canada while their case is at the general division level. So it's not unusual to do so. Um, I mean, they got if they've been contacted, they should know what Service Canada is asking for. Oh, right here. The Service Canada are reviewing my benefits, requesting notice of appeal. Yeah, I don't really know what's going on. It's hard to like have a conversation back and forth on a forum like this. So I would encourage this person to reach out for a consultation if they really are concerned about what's going on. That's what I'm going to say. Okay. Okay, we'll close that one off rather than keep going back and forth. What else do we got here? Another new one. Okay, this person says, I have a private life insurance policy separately from work and recently discovered that it offers a waiver of premium for total disability. I never knew this is even a thing until I found out after being on LTD for 5 years now. So it seems that the private life insurance can, not sure if they will due to me not applying when disability commences, waive the premiums for the duration of the disability and potentially apply it retroactively in my case. Yeah, that is correct. So what happens is this person just has a life insurance policy, and life insurance policies can have a disability waiver. It's just like applying for LTD. In fact, when you apply for many group long-term disability, they also assess you for a waiver of premium as well. And if it is a separate benefit, the waiver of premium is a separate benefit. And in this case, it's a benefit just on his life insurance or her life insurance. So this is very good information. So I'm going to recommend they do apply. If I will try and apply. There we go. So I'm just saying that they may limit the coverage. So this person's like 5 years late. They may not go back 5 years to cover the premiums going back 5 years. They may limit it to 2 years because of limitation periods and things like that. There are time limits. Now, I do think this is one where it's a late application. So when you get into these late application situations, there is when there is a good reason for the delay and no prejudice to the insurer. So hopefully this person gets it. The waiver premium what it does is it's basically they waive the need for you to pay the premiums while you're on disability. So it saves you money. Like premiums can be quite expensive on some of these things. All right. Any other questions we got here? Looks like we covered them all. I know we had King Charles. I want to say Prince Charles, but King Charles was speaking today in Parliament, if I'm not mistaken. Just going to double check, see if there's any news on the Canada Disability Benefit. Oh, there is some news here. We got some news. Let me share here. Interesting. Okay, sorry. I need a producer to help me manage all this clicking of buttons here. Okay, let's see. Right here. New as of last night, Ontario government. Oh, you're not seeing it. Sorry. So this is from CTV News. It's saying Ontario government exempts disability benefit as income. So the Ontario government announced today that, so this would be late yesterday, that the Canada Disability will be exempted as income. That's good. That means they will not treat it as income for provincial disability benefits. This is what we thought they would do, honestly. But Alberta, it is, so as far as I know, Alberta's holding the line in not exempting it as income. Currently, they offer a maximum of, yeah. Oh, that's the extent of it? Oh, well, that's quite a short article. I thought there would be more to it than that. Darn, I thought there was more to it than that. Well, that is good news, though. So it looks like Ontario was one of the few that we were missing. See if I can find a better article. There we go. CBC has a better one. Let's go look at that for you people that are interested in this. Here we go. So CBC says Ontario won't claw back the federal disability benefit. Advocates are relieved but say more work needs to be done. So this little history on the Canada Disability Benefit. In a news release on Tuesday, the province announced it will be exempting the federal benefit as income. So it won't be deducted from ODSP. Disability Without Poverty. Okay, that's a very well-known group. Said the news from Alberta stoked fear and disappointment within the disability community. Yeah. I think it's only Alberta that's not exempting it. Yeah. Now, so this person from the Disability Without Poverty, which is a disability advocacy group, they're saying in order to be eligible for the Canada Disability Benefit, must be approved for the disability tax credit, and that they must receive certification from a medical practitioner. And what we're seeing now is people scrambling to sign up for the disability tax credit. Yeah, that is what's going to happen. Which is fine when people have family doctors, but there's maybe 2 million people without family doctors. Yeah, that's going to be a problem. They're advocating to cut the red tape. Folks that are in the provincial system have already filled out medical forms that have already attested to their disability, shouldn't have to complete the kind of scrutineering process again. Yeah. Yeah, I can see why they would want to do it that way. Unfortunately, like the way it's set up, they have decided to go with the disability tax credit, and the requirements are different between the two. Although I don't see a lot of situations where, well, no, there might be, yeah, there still might be situations where you qualify for one and not the other, but it definitely is a red tape situation. Okay, we got some more questions in here. XRP says, thank you for answering. You're welcome. And just if you have any more follow-ups, just let me know. Then we got Class A asking, my LTD has recently been approved. Will I expect them to still call and check in with me? My LTD, will I expect them to call and check in with me? How often? Yeah, like if you've just been approved, like brand new approval, they will be checking with you quite a bit. It all depends on the situation and like what your medical condition is, what your treatment, what's going on. They definitely can be more or less active in following up with you, just depending on, it really depends on your medical condition and the treatment you're getting and the individual you're dealing with from the insurance company sometimes. But you should expect a lot of follow-up within the first year. Well, really within the first 2 years, there's a lot of follow-up, especially if things are moving quickly with your treatment. There's then again, yeah, you should expect some follow-up. What questions will they ask you? They're mostly interested in your treatment and what's going on with your treatment. That's mostly what they're going to be asking. At a certain point, they will start asking more about, like, if it looks like you might be on the disability benefits for the full 2 years that most people have for the own occupation, they will start asking about your work history, your education background, and all that kind of stuff. They also may ask a bit about your work environment to try to figure out if maybe you should be applying for workers' compensation. So, like if you're suffering from depression or anxiety, they'll try to figure out, is there a workplace cause of this? So they could be asking about that, trying to figure out if you should be applying for workers' compensation or something like that. Good luck, though. I'm glad to hear you got approved. See what else we got. Is there any other news? Basically, what we're waiting on is to find out how the application process is going to work. Yeah, there's nothing here. All right, it's good for checking in with you guys. If there's no questions, I'm just going to call it a day here, and I will be back tomorrow. So tomorrow I'll be back. Nothing planned specifically. I do a call-in show on Thursday. Sometimes we have people call in, not recently, but I'll have the phone number available if people want to call in. That way you can kind of talk over the phone. People won't see you, but they'll be able to hear you, and it's just easier to get advice that way. But I can understand not a lot of people want to be talking live on the YouTube for everyone to hear. But if you do, I'll be back tomorrow, same time, same place. I wish you guys all the best, and I'll see you back here tomorrow. Take care.